because after all, life comes through young girls and women. Choosing one is not letting go of the other. Hello everyone, my name is Margaret Nyambura. I am an advocate of the High Court of Kenya and particularly an advocate for health rights. I work at Kelin, but sometimes I join the legal caravan as a network lawyer. Today I come to you as a network lawyer with the legal caravan to speak about some aspects of sexual and reproductive health and rights with a particular focus on the right to abortion. So for the past 16 years, Kenya has had the Constitution of Kenya 2010 in application, and unfortunately most of the young girls and women living in Kenya are not aware of the fundamental rights that cover their areas of health, such as Article 43, which specifically has a mention on reproductive rights, including the provision of medical services, as well as Article 26, that provides for the circumstances under which a person may access abortion in Kenya. Today is 1st of April, which means we've just completed the International Women's Month globally, and the theme for this year was Give to Gain. The language that has been used in Article 26 for the Constitution of Kenya has been the foundation for most of the advocacy that organizations such as the Legal Caravan and Kelin, which I am affiliated to, use to advocate for the fundamental right to abortion. The phrasing and even the intention of the lawmakers during the Bomas process in Kenya was that abortion would be placed under the right to life, and this unfortunately opens up that right to interpretation. So for some people, it is considered an exception to the right to life. I, however, am of a different persuasion, and I'd like to invite you to consider this. Are we talking about preservation versus protection? And are we saying that we are going to preserve life at the risk of protecting young women and girls? One of the expectations that young women and girls have in Kenya is that the government of Kenya, through the Ministry of Health and particularly the Department for Medical Services, would take on active steps to provide services for not only post-abortion care, as is the norm right now, but a system that has got a health system that is strengthened enough to address, or rather to provide for the circumstances that are foreseen under Article 26(4). In 2020, countries globally were responding to the COVID-19 pandemic. But among the concerns for the respiratory virus that was going around was a more silent pandemic of the lack of access to sexual and reproductive health and rights by women and young girls globally, because they were not able to access healthcare facilities, or the healthcare providers were not able to go to their places of work and therefore to give these services, which were much needed. People turned to self-care measures to meet their sexual and reproductive health and rights. So this has brought into a sharper focus the need for the individual to take control over their sexual and reproductive health and rights, either by ways of administering contraceptives, which are easier to apply without a trained healthcare professional present, or in the vicinity of a health facility. One very popular contraceptive that is now being administered in pharmacies all over Kenya is the DMPA-SC, that has also been widely acclaimed by one of the partners of the Legal Caravan, the Reproductive Health Network of Kenya. Like with any other advocacy campaign that accompanies the introduction of a new commodity in the market, it has been relevant for the Ministry of Health to endorse and to launch self-care guidelines for use by any young woman or girl in Kenya, young girl or woman in Kenya, who would need to also administer a commodity that is associated with their sexual and reproductive health and rights. It is worth noting that regional politics also play a very big role influencing the attitudes, thoughts, and beliefs of young girls and women in Kenya as far as sexual and reproductive health and rights are concerned. More recently, we saw what the Trump administration had for priorities and what effects the America First global health strategy has had on the sexual and reproductive health and rights of young girls and women all over the country, and Kenya was not excluded. In Kenya, we have also seen the effects that the global gag rule, and particularly the more enhanced one that is in place now, what effects it has had on the sexual and reproductive health and rights of women who not only relied on externally funded projects for purposes of information, but also provision of commodities, the research that they rely on for an evidence base for purposes of advocacy, but also because of the referral systems which were in place before. So advocacy for sexual and reproductive health and rights has been done for so many years now, but the advocacy continues because the standard is for the highest attainable standard of health, including reproductive health care. And the approach to get there, particularly in Kenya, is for progressive realization, that at any point in time, the state should ensure that the standard of healthcare, including reproductive healthcare, and particularly the provision of services, is the most that the administration of the day can give to its girls and women. I would like to remind us that the fundamental right to abortion, or rather the fundamental right to all reproductive services, are not a question of preservation of the right to life versus protection of the girl or the woman, because after all, life comes through young girls and women. Choosing one is not letting go of the other. It is also worth remembering that the Bomas process that gave us the Constitution of Kenya 2010, a document which is hailed all over for how progressive it is, were not at fault when they expressly worded Articles 43, Article 26, and all other articles which support the reproductive rights of young girls and women. It is not a lofty promise which cannot be actualized, but the progressive realization of it is actually possible. It is only possible if the people are aware of what their rights are and are therefore able to hold the duty bearers responsible for the incremental steps towards the actualization of this ideal. So an enlightened electorate is therefore able to put in office decision makers who are aware of how fundamental these rights are to the quality of lives that they lead, and therefore to make appropriate choices when they go to vote.
After the recording of this video, you may have seen in the news a highlight about a recent Court of Appeal judgment which was delivered on the 24th day of April 2026, addressing some aspects of abortion. It is concerning that the highlights read that abortion is in effect not a fundamental right in Kenya. We here at the Legal Caravan would like to explain what the Court of Appeal meant in a judgment that was more procedural than it was substantive. Let's remember that appeals are filed at the next higher court in relation to the court that has issued a judgment and are strictly related to the matters which have been raised, which we refer to as grounds. Now, in this particular instance, the Court of Appeal stated that if the article of the Constitution, Article 26(4), states that abortion is permissible where in the opinion of a trained health professional there is need for emergency treatment, that the life or health of the mother is in danger, or if permitted by any other written law, then any other service that is offered beyond these limits can be termed to be quote-unquote unlawful. The Court of Appeal then therefore says that these are the bases which are covered under sections 158, 159, and 160 of the Penal Code, and which lay the basis for the filing of criminal proceedings on anybody, including PAK and Salim from the Malindi judgment, which you may be familiar with from a previous recording by Timothy Thondu, also a network lawyer with the Legal Caravan. I would like to put it to you that currently there is a proposed Penal Code Amendment Bill 2026 that seeks to include a clause that covers or limits criminal liability where it takes away the aspect of offensive nature of for any person who acting in accordance with circumstances contemplated under Articles 26(4) of the COK, which is the Constitution, then there is no criminal liability. Let's remember that the Court of Appeal decision was issued on the 24th day of April, and this Penal Code Amendment Bill is as fresh as March of 2026. Let's also remember that the Court of Appeal stated that because, in effect, the judge in Malindi, presiding over the PAK case, terminated the criminal proceedings, this termination was a frustration of the rule of law, which is applicable in Kenya and which provides for accessible and impartial dispute resolution. What do I mean by this? That cases should have independent adjudication, that there should be equal enforcement of the law, and that supremacy of the law also includes protection of rights. That even as somebody is facing criminal proceedings, it is still possible to have constitutional safeguards in place. Given this reasoning, the Court of Appeal then proceeds to say that it is going to abstain and even veer off from addressing the component of abortion which was addressed by Justice Nyakundi in the PAK case, and instead says that the lower court should have heard and determined the case and made its termination to the full. On this ground, it further decides to reinstate the case against PAK and Salem and says that it should be fully heard on merits and a finding made on lawfulness, with the procedural aspects for seeking constitutional safeguards still available to them and the avenues for appeal still available beyond that.
I hope all of you have registered to vote. Don't watch this video if you haven't registered to vote.